Thank you very much, Andrew, and thanks to the organizers for having me here. And Mike, thanks to you as well for making clear that those vampires in the room weren't the M&A lawyers that you were working with. As you were describing them, I was worried where it was going at that point. Yeah, exactly. I thought what I would do in my time is turn off the PowerPoint. Deal with, just very briefly, a couple of minutes on basic privacy law obligations when you're collecting, using, and disclosing personal information as part of your business, which tees up sort of the three specific areas that I want to deal with, which are the privacy implications when you're collecting a pharmacist's personal information to use in your business, when you're collecting script or prescription information from pharmacists, and then finally, use of anonymized patient data, particularly in marketing purposes. So in terms of the basics, I seem to have, like all things in Canada, there's no simple answer to what law governs your business when it comes to privacy. As I say in this slide, there's a real patchwork of legal regulations that to some extent depend on your geographic location, the location of the individuals from whom you're collecting information, can depend on the nature of the personal information. If you're dealing with personal health information being collected from healthcare custodians, you're going to be primarily governed by provincial legislation. And then finally, there's an issue as to whether you're federally regulated or not, which will inform what law applies. But for our purposes, the important obligations to think about are all the same in all these various laws. There's really three core concepts. One is you have to have some form of consent to collect, use, and disclose personal information as part of your business. Once you have it, you've got an obligation to safeguard it from improper use and disclosure. And you open up the Globe and Mail or any other newspaper in Canada, you know, the data breach and the class action risk associated with that is a huge issue for any business that collects and uses personal information. And the last thing is you have to be accountable and transparent to those individuals with whom you're dealing with about what your information handling practices are. But in terms of what is personal information, because this will inform some of the specific pharmacy-related questions, you have to know that it's an incredibly broad definition, and it is basically anything about an identifiable individual. So if that information is a name, can lead you to the identity of a person, then subject to some very limited statutory exemptions, it's personal information, you're subject to all of these legal obligations. Although the law is called a privacy law, all these laws, it's quite counterintuitive because it doesn't have to be private information. It can be information taken or gleaned from the internet or otherwise publicly available. The other important point, and this we'll come to when we're talking about anonymizing data, that is de-identifying it, is that information, even if it doesn't include a specific identifier of an individual, if it includes information that can lead to the identity, then it's personal information. So you'll see things like dates of birth, postal codes, addresses aggregated together. That information can comprise personal information and be subject to the legal obligations. So just very briefly on what does it mean to consent. The core obligation in all of this legislation is you have to have some form of permission to use and collect the information. But the important point from the perspective of dealing with pharmacists is consent has to be informed, but it can be implied, which is important. It doesn't always have to be written out. So those are some of the basics. Let me turn to some specific questions, and you can use your clickers here. So this question comes up fairly frequently. So a sales rep determines a pharmacist's birthday, wants to send flowers and a card. Are they going to privacy jail for that? Vote, if you will. So interesting, yeah. So you're all obviously, or at least 44% of you are well versed in the privacy laws. Yes, this is personal information. Somebody's date of birth, it's considered sensitive personal information that can be used and misused for all sorts of purposes. So for those of you who said no, go forth and tie your camel, as they say. So Just briefly, what do you do in real life circumstances? You don't need to be a marketing professor to know that if your first interaction with somebody who you want to do business with is to slide a consent form in front of them and say, sign off, I want to use all your information, that's not going to be a very effective relationship. So written consent in these circumstances isn't realistic, but you can get implied consent. You can have standard terms and conditions on your website and your other marketing material directed at healthcare practitioners, pharmacists that say we'll collect and we'll use this information. But a best practice is you got to be somewhat obsequious and limited about what you collect. We heard about big data. There's lots of benefits to collecting lots of data. There are potential burdens to it too. And so have your people understand and realize what do they really need to effectively do their job and only collect and retain that. So here's another question that comes up quite regularly in real life. So you want to collect and use script information, right? Not directly from a particular pharmacist. So you want to target, who are the really productive and useful prospects in the shopper's chain that we want to get. So do you require the consent of that pharmacist to get the information on what scripts they're filling, when they're substituting, when they're not, etc. So vote away. See, now you've all become highly privacy sensitive, and you're wrong if you were in the answer. The answer is no, you don't. And I know IMS is involved in the conference. Very early in the privacy regulation days, a doctor challenged IMS's collection of prescribing patterns. Went to the Federal Privacy Commissioner, said, this is my personal information about showing the preference of what scripts I'm writing, what I'm not writing. That's all about me. One might have thought that's maybe a sensible application. The Privacy Commissioner said, no, that's basically like work product data. That's not your personal information. Go away. So the short answer here is you can probably use that information without getting the pharmacist's consent. Now, whether you're pissing off, to use the vernacular, a potential customer of yours by doing so, you'll have to factor that into your own risk tolerance on these issues. So next question. So a pharmacist comes to you and says, look, we're in the era where rebates are now banned. I've got a whole bunch of data that I can sell you about patients, but I'm going to anonymize it. So I'm not going to disclose personal health information to you, but I'm going to sell you a bunch of really valuable data. You're not going to get the names, but you're going to get postal code, age, gender, date of birth, history, etc. Customers aren't consenting. So can you do this? See now you're back on keel. You're not overly sensitive to privacy, and you got it. 52% of you get it right. It's not really truly anonymous data, in the sense that there's date of birth, there's postal code, and for some people, you could take that information and actually identify a person. So it's not effectively anonymized. So what do you do? In that example, you cut out the last 3 digits of the postal code. Will typically deal with that problem. So you just have to be careful when somebody is saying, we'll sell you, or we'll provide to you, or we want you to collect anonymized data, that it is truly anonymous. And it's something that trips up people all the time. So then my last example is from a real life one. So you have a chain pharmacist, not Shoppers, because this would never happen there, but offering basically to sell you all of the truly anonymized script data. And does that pharmacist have the right to do so? So you can vote away if you'd like. But the results show, ooh, pretty close. You know what? The last answer is right, and this actually came up on the sale of all the Zellers stores to Target. Zellers had their captive pharmacies, and Loblaws came along and agreed to buy basically all of the patient data and move those patients to Loblaws chain stores. A group of, I might say, philanthropically and privacy-sensitive pharmacists decided they would go to court to try and get an order saying they own this data, and their professional obligation prevented them from allowing it to be transferred without their consent and unless they got paid a whole bunch of money. My apologies to any of those pharmacists who might be in the room. The court said no. The Zellers agreements were well drafted and very clear that all of that data belonged to Zellers and that Zellers had the right to sell it. And furthermore, that the manner in which Zellers was transferring that data was completely compliant with the relevant privacy laws, which was the Ontario Personal Health Information Protection Act. So if you're a pharmacist, sorry about that. If you're in the business of buying pharmacy data, you can probably do it subject to knowing what the agreements say. So that's everything I had to say, so thanks very much.